Oh, somebody has the hiccups. Drink some water. All right, so we are back. And who are the parties on Alexander Gill? Is the attorney here on Alexander Gill? All right, we'll wait for them to come. Brian Kimbrough, we're waiting for your paperwork. Is that correct?
It should be there. I think my client completed it and sent it in. I think we're all done. My client's logged in, so we're ready.
All right, what's your client's name?
Jose Torres.
All right, I don't know if Mr. Torres has completed his paperwork because I don't have it. So what I'm going to do is I'm going to send you and Mr. Torres to breakout room number 3. And if you could see if he has signed everything.
I'll go with them there, Judge. It looks like the only thing they're missing is the court's paperwork.
Okay. Thank you, Robert.
Uh-huh.
All right, John Kuntz.
Yes, ma'am.
Hello, are you ready to proceed on Mr. Gill?
I am, Judge.
All right, who is the prosecutor on Alexander Gill?
So Tom negotiated the deal, but Marcus was helping us out with regard to the name issue that we were discussing earlier, Judge.
All right, is anyone from the state ready on this?
What case is this, Judge?
It's on Gill, but there was some issues with regards to his name that's listed.
I'm here, Judge.
Okay.
There's Marcus. Okay.
Okay. All right, the court is going to call 2017 CR 2454 and 2017 CR 10640, State of Texas versus Alexander William Gill and State of Texas versus Tommy James Gill. Could I have parties announced for the record?
Marcus Sanders for the state.
John Kuntz for Alexander Gill, Judge. And if you want to address the name issue right now, can we do that?
Just give me one moment before I address the name issue. Are you Mr. Gill? Could you unmute?
Yes, ma'am.
Mr. Gill, I'm showing you 2 documents entitled Defendant's Consent to Appear by Video. Did you review those documents with your attorney? Did you understand them and did you electronically sign them?
Yes, ma'am.
And Mr. Kuntz, are you the attorney that is listed as the attorney of record?
I am not. Megan Enriquez, my associate, is, but as you know, she's out on maternity leave, so I'm handling her caseload right now.
All right. Any objections, Mr. Gill, to Mr. Kuntz handling these 2 cases?
No, ma'am.
All right. And any objections from the state that we proceed by video?
No, Judge.
Any objections from the defense that we proceed by video?
None, Your Honor.
All right. So the court shows that the defendant is on deferred adjudication in 2017 CR 254, and he's listed as Alexander William Gill. And the court shows that he's on deferred adjudication in 2017 CR 10640, and he's listed as Tommy James Gill. So what is the defendant's name?
His correct name is Alexander William Gill. And so we would, I guess, move to amend both the motion to revoke and I don't know if this is the time to try to amend the prior judgment, but we want to ensure that that's corrected as well as any future judgments have Alexander William Gill instead of Tommy James Gill. And I believe Tommy James Gill only appears in 2017 CR 10640.
That is true. And I will say that the motion to revoke actually has Alexander William Gill. Let me, just one moment, let me do quick research.
Sure.
And Judge, we were speaking with Julie earlier.
Yes, did Julie complete the paperwork for you all or no?
We didn't do any
Julie?
paperwork.
No, there was no paperwork done.
What I'm thinking is, well, let me see you all in a breakout room. Breakout
Sure.
room number 1, please.
Okay.
Let me see. 1. All right, we are back on the record. And so that the record is clear, in each of the cause numbers, the person that has signed the consent to appear by video conference is Alexander William Gill. Is that correct, State?
Correct, Judge.
Is that correct?
Yes, Judge, that is correct.
Right, then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by video. And in cause number 2017 CR 10640, the court is noting for the record that the judgment has the defendant's name listed as Tommy James Gill. It's the court's understanding that that is the incorrect name. Is that correct, defense?
That's correct, Judge. And if you would like, I can ask my client some questions to try to clear that up.
Yes, please. If you could unmute Mr. Gill, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
Okay, I'm gonna need you to speak up.
Yes, Your Honor.
All right, you can lower your hand. Could you state your full name for the record?
Alexander William Gill.
All right, defense.
Thank you, Judge. Alexander, is your SID number 1035393?
That's correct.
And what's your date of birth?
11/15/1995.
11/15 of 95?
Yes, sir.
Okay. And you know that you were originally placed on probation a few years ago when you had a different lawyer, but the name was given as Tommy James Gill, and you were placed on probation under that name. Is that correct?
I thought it was under Alexander. I wasn't aware that it was under Tommy.
And Tommy James Gill is the name of your brother?
Correct.
And was it that you had given your name when you were arrested? Or you had given your brother's name when you were arrested?
Correct.
Did you say correct?
Yes, sir.
Okay. And so obviously, for whatever reason, it was never corrected prior to you entering into the plea bargain to get probation, right?
Correct.
Does your brother have any sort of criminal history whatsoever?
Yes, sir.
And that would be Tommy James Gill, G-I-L.
Hold on,
Oh,
hold
just
on,
one
hold on.
second. Can we
You're
go
gonna have
back?
to, you're gonna have to speak up. I didn't know if you said yes, sir, or no, sir.
Okay. So your brother is named Tommy James Gill, G-I-L.
Correct.
And what is his date of birth? Do you know?
March 16th, 1999.
So your real name on your birth certificate as you've lived your life has been Alexander William Gill, G-I-L, right?
Yes.
And okay, Judge, I don't have any other questions.
Oh, we didn't hear the response to the question of your brother doesn't have any sort of criminal history.
Does your brother have any sort of criminal history whatsoever?
No, he does not.
So he's not a felon or anything like that.
No.
And that's been you on probation as Tommy. You've been on two probations, one in 2017 CR 2454 and one in 2017 CR 10640. And in one case, you've been on probation as Alexander William Gill, but at the same time, you've also been on probation as Tommy James Gill. Is that correct?
Correct.
But you are Alexander William Gill.
Correct.
All right, any questions from the state?
No, Judge.
All right, Mr. Gill, in each of these cause numbers, I'm showing you what's entitled motion to revoke community supervision and first amended motion to revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Are you the same Alexander William Gill who was placed on community supervision in 2017 CR 10640 for the offense of theft, $2,500 to $30,000 of a vehicle on February 5th, 2018 for a term of 5 years? Is that you?
Yes, Your Honor.
And are you the same Alexander William Gill who was placed on community supervision in 2017 CR 2454 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on February 5th, 2018 for a term of 5 years? Is that you?
Your Honor.
I'm going to need you to speak up.
Yes, Your Honor.
All right, state, are you proceeding on that same allegation in each motion?
Yes, Judge.
Defense, do you have any objection to the state reading the allegation once, and your client's answer is for both motions?
No objection, Judge. I haven't conferred with Mr. Sanders specifically about this. Marcus, did you know we're going to plead to any of the violations except the Fayette County ones?
Okay.
All right, state.
From the first or the amended motion for both cases, condition number 1, on or about the 17th day of June, 2021, in Bexar County, Texas, the defendant Alexander William Gill committed the offense of possession of controlled substance, PG1, in violation of condition number 1.
How do you plead to that? True or not true?
We'll waive the rest, Judge.
Any objections to this state's waiver?
No, Your Honor, we're very grateful.
Mr. Gill, did you understand by pleading true to violation of condition 1 in 2017 CR 10640, the court could find it true and sentence you up to all right, we're going to have to go off the record. This judgment is majorly incorrect. He is charged in that case as a 3rd-degree felony, and the judgment has it as a state jail felony.
Oh, Lord.
Yeah, this was before my time.
Right.
So we're
Yeah,
gonna
don't blame us.
Okay, so we're gonna have to change the judgment. It will take a few moments to change that judgment because he's charged as a 3rd-degree felony in that case. And the judgment has it listed as a state jail felony, but it should not be.
Okay.
So if you all will give us a moment, I'm going to have the council come in to change that. And we can might as well change the name for that judgment while we're here. And let me make sure there's nothing wrong with the other judgment. The other judgment is fine. So let me have that attorney come in, and she'll be able to do it very quickly.
Okay.
All right, just everyone be patient. Give me a moment.
John, could I see you in 4 real quick?
Did you ask to see me?
John.
Okay.
If there's a host that can place me in a breakout room with Juan Martinez, he's in the Bexar County Jail, so we can review plea paperwork.
All right, Mr. Hernandez, I sent you to breakout room number 3, and your client is in number 3. All right, and Jonathan Chavez, who are you here for?
Adam Ayala, Your Honor.
Okay, isn't this supposed to be for a motion to suppress or no?
It was a motion to revoke, Your Honor. I had notified the court or Norma earlier and Tom Nisbet. Mr. Ayala tested positive for COVID this morning. I got the documents over.
Okay, why is this listed as a motion to suppress?
I wondered the same thing.
Okay, so, all right, so is this going to be a contested motion or no? Mr. Chavez?
Yes, my internet is going in.
That's okay. Is this going to be a contested MTR?
I was going to ask if I could get in a breakout room with Mr. Nisbet.
Okay, let me send you. I'll send you to breakout room number 2.
Okay, thank you, Your Honor.
You're welcome.
Judge, if I can get into a breakout room with Mr. Navy.
Okay. And Nathaniel Navy.
I'm here, Judge.
All right, I'll send you to breakout room number 5.
And Your Honor, I've been chatting with Norma. She gave me the August 23rd trial date is what works best for the court. And
All right, just give me a moment.
yes, sir.
Judge, something else came up. Can you join us in 4 when you have a chance?
Yes, I'll be right there. Okay, oh, well, now I'm signing things right now. Is that Luis Torres? Yeah. Yes. Okay, so I'm signing it. Oh, that one we're still working on. All right, everyone. If you have some patience in your pocket, take it out. If you have a lot of patience in your pocket, share with other people on the Zoom. I hope yes.
What number do I go to, Judge?
You are going to number 2.
Thank you.
You're welcome. All right, everyone, I'll be right back. I'm not asking for this. Yeah, because you're asking for like what it lower than what it is. Which makes, from our perspective, makes no sense. All right, and Ms. Patterson, if you go to breakout room number 4, thank you. All right, and Tom, did you have a chance to confer with Mr. Chavez on Adam Ayala?
I can't even talk to him. I don't even think they have internet over there. I don't know, like he completely freezes every 2 seconds.
It's Friday, but it's Monday. Oh, Julie, I
Yes.
sent you to breakout room number 4. John Kuntz and Marcus Sanders are in there.
Okay.
There are more issues with that judgment than first anticipated.
Okay. Sounds good.
All right, thanks. Okay. Alice Warburton. Alice? All righty, we'll be back with that. Who is the party?
Hello,
on-
Judge. I'm so sorry. I was trying to unmute. I'm Chris Allen with Miss Alice Warburton.
No,
Yes,
I mean,
Judge.
I need your attorney. I didn't need. All
I'm present, Judge.
right, well, I need to show you see your video.
Okay, yes, Judge. Just 1 second. I'm having trouble with it, Judge.
Sure, no problem. All right, Tom, Kalfas and they're coming back into the Zoom. So I'm sending them to number 2. We'll see what happens. Kalfas Law, if you go to breakout room number 2, please. And Julie, were you able to go into the breakout room when?
I went there and they told me to come back. So if you'll send me back, that's right.
Okay, yes, you could go back.
Okay.
All right, thanks. All righty.
Can you
Alice?
send me back? Like, do I need to do something?
Oh, no, if you just go to the bottom where you see breakout rooms, you're able to go back to that room.
Thank you.
Oh, you're welcome.
Sorry, Judge, I'm having a lot of trouble with this.
Everybody's having trouble with their Zoom today. We will see. Who's the prosecutor on this?
Mine?
Joe Ray, Judge.
Okay. All right, court is calling 2020 CR 6558, State of Texas versus Christopher Wayne Allen. Could I have parties announced for the record for the state?
Joey Garcia.
For the defense?
Alice Ward.
All right, and are you Mr. Allen?
Yes, Your Honor. Good afternoon.
Good afternoon. We're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No.
Mr. Allen, do you have any objections to this proceeding by video?
No, Your Honor, I am fine. Thank you.
All right. It's the court's understanding that an offer was tendered by the state. Is that correct, Ms. Warburton?
It has been, Judge.
And is your client rejecting that offer?
The client is not willing to accept the plea bargain that has been offered by the state.
All right, Mr. Allen, can you unmute yourself, please?
Yes, Your Honor.
Are you requesting a jury trial?
I was originally, we had been speaking about.
No. This is where we
Yes,
are.
ma'am.
Where we are
Yes,
is
Your Honor.
the state tendered an offer to defense. Defense is telling me that you are not accepting that offer. Is that correct?
That is correct. Yes, ma'am.
So you're requesting a jury trial?
Yes, Your Honor.
All right, you can either do a jury trial or a bench trial, but if it's a bench trial, the state will have to agree. And of course, your attorney will discuss that with you.
Yes, Your Honor. Thank you for that.
All right, so you're requesting a jury trial or do you want a bench trial?
A jury trial will be great.
All right. Defense, have you received all the discovery in this case?
As of today, Judge, yes, Mr. Garcia did let me know the last time he has spoken with the witnesses that he intends to call. My only request would be that Mr. Garcia double check and make sure that I do have a witness list. And otherwise, I have had all the discovery. I checked that this morning.
All right, and the court will note for the record that there was a discovery acknowledgement that was submitted on August 4th, 2020. Have both parties had a chance to confer on a jury trial date?
Yes, Your Honor.
And what date will that be?
We are available on August 23rd and the September 8th date, and it is at the court's convenience, whichever you would like, but I'm available on both those days.
All right, Mr. Garcia, August 23rd or September 8th?
I thought it was September 15th. I don't know if there's one on the 8th. I could be wrong.
All right, Ms. Ferguson,
Yes, ma'am.
what is the date for the jury trial on Mr. Allen?
August 23rd, Judge.
All right. So August 23rd. Any objections to August 23rd as a jury trial date, state?
No objections, Judge.
Defense, any objection to August 23rd as the jury trial date?
No objection.
Mr. Allen, do you have any objections to August 23rd as the jury trial date?
I do not, Your Honor. Thank you.
All right, then Mr. Allen, you will need to be in the 187 District Court on August 23rd at 9 a.m. for jury trial. It's the
Yes, ma'am.
187 District Court, 300 De La Rosa, fourth floor. Do you understand?
I do. Yes, ma'am.
All right, so what date do you need to be here for a jury trial?
August 23rd at 9 a.m.
All right, and where are you going to be headed on that day?
300 De La Rosa, floor number 4.
All right, 187 District Court.
Yes, ma'am.
All right, if there's nothing else, we'll close the record.
Nothing further, Judge. I'll see you on the 4th floor on August.
All right,
Thank you, Your Honor.
everyone. You're welcome, everyone. Have a good one. Thank you.
You too.
Great summer. summer, everybody.
All right, you too. Everybody stay dry. Bye-bye, Mr. Allen. All right, Tom, did you have a chance to confer with Mr. Chavez?
Yes, it quickly broke down when I was called an expletive. So Judge, I guess I am now in receipt of the defendant's positive COVID test. It looks legit. That is what it is. Beyond that, I don't know what kind of motion the defense wants, whether it be contested or suppression, or I'm not sure at this point, but I'm going to need an in-person hearing for presentation of evidence. I won't consent to do this case over Zoom. And in light of the defendant being sick, obviously that'll be reset until he's not. And that is where we are at.
All right, so is this going to be a contested motion to revoke, Mr. Chavez?
It looks like that, Your Honor. I will say we need a motion to suppress on the motion to revoke. It's a new number 1.
Okay, so this is why I was set for a motion to suppress. Everyone, I was asking that question. I knew Norma wouldn't put a motion to suppress on the docket. All right. So Norma, what date would you like to bring them back?
Is that Mr. Adams?
Adam Ayala.
Ayala.
Okay. So in 2 weeks? Or does he need more time to?
Well, the state will need to get their witnesses. If the defense has any witness, they'll need witnesses. And it has to be in person.
Right. And then obviously the defendant would have to have a negative COVID test, I think is what Norma is asking.
Yes. So I don't know when he
They actually don't
contracted.
do any other follow-up tests on COVID testing, because I tried to go get a COVID test for a negative test. They don't do that anymore.
All right, so this is what we will do. Let's set it the normal time frame. We would set it, Norma, if when people tested positive elsewhere. And what we'll do is set it in enough time so a week out from that date, he'll have a chance to present with a negative test if he chooses to do so.
Okay.
And how many witnesses is this going to be? Does anyone know? Just an estimate. I'm not holding anybody to it.
5E, 6E, probably.
All right. And Jonathan, I'm not holding you to it, but are you anticipating calling maybe different witnesses than the state has?
I think just cross-examining the state. Well, one witness at least, Your Honor.
Okay. So probably like about 7 to 8 witnesses, Norma.
Well, I'll still be in the afternoon, Judge.
Yes.
So you want it sometime in August?
No, we can do August. But not August 18th. If you set it August 18th, I'm gonna have my brother call you.
And it's gonna be Tom doing it, correct?
Yes, I think so.
Okay.
I mean, I tell you what, if you, Tom, and Jonathan want to go to a breakout room and confer over a date, would that be best?
Yes, ma'am.
All right. So Tom and Jonathan, if you'll go to number 1, and Adam, I'm going to send you to number 1 as well, so that you all can get a agreed upon court date. No, it's just been so long. And who is on Juan Torres?
One.
I'm sorry, Jose Torres.
Yeah, Brian Kimbrough. We're ready.
All right, it's Monday, people. It's Monday. Thank you, everyone, for really all of your patience. Oh, thank you. I appreciate it. That one, I think we're done with. This one, I'm still, what's the name of that one?
For Alan?
Yes, that's done. But these I'm still working on. Yes. Hunter, is this you?
Yes, Judge.
I mean, once you told me, because I wasn't really thinking about that, once you told me it was Debbie Stevens, I like, what? That's already an offer. Now I get why.
Tom, if you would go back to breakout room number 1.
So it's not recorded. The breakout room's not recorded, Judge, and I don't want to go in there without, if he's going to swear at me some more, I'm not going in there and it's not being recorded. So I'm not going in there.
Okay. All right, Norma, can you go to number 1 and tell everybody to come out?
I don't know if we.
It's Friday.
Maybe we can do.
Everyone, just give me a moment.
Front setting. Or we could, you know what? Different courts are handling that differently. Like some are like, oh, well. But at the same time, you're going to practice. Yeah, let's just go ahead and put it on, because otherwise I don't want it to fall off the radar. If it's something that you can investigate whether or not that would work. Like, because he wouldn't even take that. Okay. And by the way, is his sister or whoever Amanda is, are they testifying? And by the way, we just found out that the victim is actually there. So we have our advocate. I hadn't even really talked with them. He's studying in such a new. I mean, I was always impressed with it. And I haven't even made it on. We haven't put it on the bond issue, and so we haven't even really talked to him. And so I don't even know what's going on down there. No, I'm not. Not at this point, because I don't feel comfortable putting him up there without knowing what his mental state is.
All right, we are back. So, Norma, on Kalfis and Adam, do we have a date? Oops, sorry, I'm on mute. Yes. do you have-
We'll give them what, 4 weeks?
Yes.
Well, let me see what we'll just give them 4 weeks.
Okay, what's the date?
That's not the 18th, right? So we can do.
Nope.
Hold on. How about we just do the 30th? We'll just leave it at that.
All right, Jonathan, is August 30th okay with you? Oh, you're on mute.
Yes, that'll be perfect.
All right, Tom Nesbitt, August 30th.
That's fine, Judge.
Okay, so we're gonna come back on August 30th. at 2 p.m.
And Judge, I'm sorry to interrupt, and this is gonna be for a contested MTR?
Yes, this contested MTR. We can do the contested MTR and the motion to suppress all in one going, I think. All righty. Is there anything else?
No, Your Honor.
All right, thank you. I'll see y'all then, Mr. Ayala. I hope you get better.
Thank you. Have a good day.
All right, thank you. You too. All right, we're on Jose Luis Torres. Court is calling 2021 CR 3050, State of Texas versus Jose Luis Torres. Can I have parties announced for the record, please, for the state?
Morris.
For the defense?
Brian Kimbrough.
And are you Mr. Jose Luis Torres?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Torres, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? Did you review it with your client?
Yes, Your Honor, I did.
Mr. Torres, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Judge. Waiving count 2, it looks like.
Oh, okay. All right, any objection to count 2?
No.
Mr. Torres, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
I believe so, ma'am. Yes.
Right, what you're charged with and count 1 is possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call them the right to remain silent. Mr. Torres,
Yes, ma'am.
did you understand you have a right to jury trial, the right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Torres, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Definitely.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. They're requesting a $1,000 fine, recommending deferred adjudication, taking into consideration 2021 CR 2968, County Court Cause number 652898, and there's $57 restitution for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Judge.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision of deferred adjudication be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution, MIALF evaluation, and the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Did offer state's warrant attachments, Judge.
Any objections?
No objection.
Mr. Torres, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yeah, I'd like the court to follow the plea bargain as we presented it. I believe he will successfully complete his probation. So that's all I have.
All right, Mr. Torres, who is Venus Jeanette Juarez?
That is an ex-girlfriend.
All right, do you all have any children together?
Negative.
Do you have any children?
Negative.
How long have you been using ice and these other drugs?
It's been going off and on for about 5 years.
All right, why did you start using?
I got around the wrong crowd and started hanging with the wrong people.
You know what I always tell people when they say they hang around the wrong people?
No, ma'am.
You know what? If I had Jeanette before me right now, you know what I asked her? I said, are you dating Jose Torres? You know, she'd tell me negative. And I would say, well, why are you using drugs? And you know what she'd tell me? hanging around the wrong people, getting involved with the wrong people. And I'd say, well, who are these wrong people that you're hanging around with? And she'd say, Jose Luis Torres. So there you go.
Yes,
So
ma'am.
these are choices you're making. Are you employed?
Yes, ma'am.
What do you do?
I'm a lift operator.
If you're drug tested today, and know that I can have you drug tested today, what are the results going to be?
Negative.
All right, you're going to get drug tested today. So you're sticking with it's going to be negative?
Yes, ma'am.
All right, there will be no
I've been doing-
excuses. What?
I've been doing good for about 6 months here. So,
All right, so we're going to get a UA today, okay?
yes, ma'am.
Your Honor,
So
in
I've
terms of
seen somebody,
you're getting a UA today,
yes.
given that it's what, about 3 o'clock and it's going to start pouring rain.
Oh, I know people. He'll be able to get his UA.
Excuse me?
So there's not going to be a problem with him getting a UA.
Okay.
Yeah. All right. So I noticed somebody walking back and forth behind you. Do you live by yourself or are you living with someone?
I live with my mother.
Right. This is what the court is going to do. $1,000 fine, that will be probated. 5 years deferred adjudication. Is there a reason there was a suggestion for a McMilef evaluation?
Judge, I believe during intake,
If I could answer that, he did they did a mental health evaluation. I think it was when he was magistrated. And on that evaluation, they checked off no history of mental illness, but for some reason they did check off the box that he has a mental problem. Now that was the only indication that there's a mental illness issue. That's the only one that I'm aware of. And I spoke to Mr. Torres. He said he's never been evaluated. He's never been diagnosed or taken any medication for mental illness. So I don't know why that was checked, but I believe that's the only reason why we're doing this.
and Judge, if I may,
Yes.
one of the cases taken into consideration kind of gives a little bit more insight to it, but basically there was no history seen up until the second half of 2020 when he picked up 4 or 5 cases. And so it was an interesting development in a very particular part of time, and the behavior observed in the cases raised some cause for concern, coupled with that indication on the magistrate's report.
Okay. All right. So I'm going to do a McMilef evaluation, the MRT. Take in consideration 2021 CR 2968, County Court cause number 652898. There's to be no contact with Venus Jeanette Juarez, JURAREZ. 150 hours community service restitution. He's going to have to do those hours. I will not allow him to buy those out. He's going to do a UA today. There's going to be regular Zoom reporting or by phone, or in person. So Mr. Torres, if something happens and your internet is not working or you can't Zoom, you need to report in person. There'll be random UAs, or you can either do the patch. Probation will speak to you about the cost of each. 2 times per month, random field visits. $57 restitution for laboratory testing. Mr. Torres, I'm going to try you with just NA meetings, but if you end up presenting with a positive test, Rebecca, I'm going to want him an intensive outpatient treatment. But we'll do NA. Yes.
Your Honor, I just have a question. I work 12-hour shifts 6 days a week now. My only days off are Sundays, so I feel like that may be a hindrance to that. I don't know.
NA meetings are like 24 hours available, 24 hours throughout the city. You can go to NA meeting on a Sunday. You can go to an NA meeting on a Saturday. It's completely up to you. But you need to do
Okay.
NA meetings at least 2 times a week.
Yes, ma'am.
And let me just tell you, I'm not doing this to punish you. It's just based upon my experience as an attorney in all of the treatment courts and my studies about people who have drug issues, that they have to stay busy. Because
Yes.
when you're not busy, what ends up happening is you hang out with the wrong people and you start using. I read the police report and I'm shocked that people are still using LSD. Usually that was from the 60s, but Brenda, as I say, these are children. So, all right. So NA meetings 2 times per week. Rebecca, is there anything else he needs?
The proof of employment?
Yes, thank you. Proof of employment within 15 days. There's to be no employment with vulnerable people. So what that means is that you can't be a home health care provider or involved in any employment that involves minors. Do you understand, Mr. Torres?
Yes, ma'am.
All right, Mr. Torres, is there anything else you need from the court in order to be successful?
None that I can think of at this time.
All right, if you need something to help you be successful, please let probation know. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you have waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Torres, good luck to you. We can go off the record. Mr. Torres, I was looking at the report at the time of the offense. You're 25 years old. You're probably 26 now. Here's the thing. You live at home with your mom. That means that that's your mom's house, your mom's rules. If your mom gives you a curfew, you need to follow that curfew. If you don't want to follow a curfew, then you need to start living at your own place. You understand?
Yes, ma'am.
So respect your mom and respect her house.
Yes, ma'am.
All right, I'm going to send you to breakout room number 1. And Mr. Kimbrough, you can go to 1 or either you can be excused. Thank you for your patience. Have a great rest of your week.
Thank you.
All right, bye-bye.
Sorry.
Anyone else ready?
There you go.
Who's ready?
Judge Luis Martinez.
Yes, Luis Martinez.
Judge Joe Ray and I need to confer with you about a PSI that's set on your docket today.
All right, if you will go to breakout room number 2, I'll meet you in breakout room number 2.
Judge, when you have a moment,
Yes.
you're requested in breakout 4.
Oh, I did?
Yeah.
Listen, oh, okay. So let me go to 4 and then I'll come to 2. Okay, see, now after I have to be in all these breakout rooms, I'm like, how do the prosecutors and attorneys do this? Going to all these different breakout rooms. I'll be right back.
Just wait.
Yeah.
I know. That's like, hold on a second. It's so weird.
Oh, no. What'd you say? What'd you say? What's your name, Stacy? Tracy? What's your name? I'm gonna go over there right now. Stacy? Tape on top of tape. And Amanda Shepherd, she's eating, right? Uh-oh. You see it? On mute. He keeps on muting. He's muting himself. Yeah, that Amanda Shepherd still eating something.
All right, Norma, could you go to breakout room number 2, please? And Mr. Ramsey Gonzalez, if you could go to 2, please.
Yes, ma'am.
And John Kuntz and Marcus Sanders, and then I'll take you up. Let me see, you're covered. Mr. Vale, just give me one moment.
Judge, I just want to make sure you could see me with my blue tie. That's all.
I like your new tie.
I mean, your bailiffs have been, slapping me around. I wanted to make sure that I look good for you. And they show me how to walk here and talk and what buttons to push. So I'm good. I just, I'm sorry I'm running a little behind.
All right, just give us a moment. Mr. Jose Torres, Rebecca, are you guys finished with Mr. Torres? All right,
Yes,
Mr. Torres, you're excused. Go take your drug test. All right, John Kuntz.
Yes, ma'am, I'm here.
All right, let's proceed.
Now, Judge, I have not had a chance to explain to my client what's going on, but Alexander, everything's fine. You'll understand what's happening when we're doing it, okay? You're only gonna plead true on the one case and be revoked on the one. The other case is gonna get wiped off, okay?
Okay.
The other probation that had you in the wrong name with the illegal sentence, that's gonna get wiped off.
Okay.
And that was done before my time. And
Mine
I
too.
believe that was before Marcus's time and before John
All of us.
Kuntz's time.
All of us.
All right, the court is calling 2017 CR 2454, State of Texas versus Alexander William Gill. Can I have parties announced for the record, please?
Marcus Sanders for the state.
John Kuntz for Mr. Gill.
All right, and just so the record is clear, all parties have agreed to appear by video. Mr. Gill signed a document entitled Defendant's Consent to Appear by Video, and he agreed to appear by video. Mr. Gill, I'm showing you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
And with regards to that case number, my understanding is that the defendant has previously pled true to violation of condition number 1 from the First Amended Motion to Revoke Probation. Defense, does your client still wish to plead true to violation of condition number 1?
With regard to the number 1, that is the Bexar County case, yes.
Okay, and that is the number 1 case. All right, Mr. Gill, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you to 8 years in prison and a $1,500 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. We're asking that you grant the motion, revoke and reform the underlying sentence from 8 years to 5 years and sentence him to the 5 years.
All right, is that an agreement?
Yes, Your Honor. And as a part of that agreement, they're going to take into consideration the new number 1 drug case that occurred here in Bexar County in June.
That's correct, Judge. That case number is NIGhtMag 618953.
All right, Mr. Gill, are you asking the court to follow that agreement? I can't hear you, Mr. Gill.
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement, sentence you to 5 years in prison, give you credit for any time served, take in consideration NIGhtMag number 618953. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Also, because this is a felony conviction, you are not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, if there's nothing else, we'll close the record.
Actually, Judge, if I could address the jail credit issue real fast.
Yes.
I called your clerks this morning and they told me that on this case, on the 2454 case, he has 321 days of actual credit in the Bexar County Jail. I've also spoken to the probation officer assigned to your court, and he was in the ISF program, which would not be reflected in the Bexar County CJIS system, from April 15th of 2019 to to August 1st of 2019.
April 30th.
My calculation, it's 108 days. So he would get 321 plus 108 days.
I think Rebecca said a different date. What was that? April?
The beginning date was April 30th.
But the beginning date of the program, but you told me that he'd been transferred from the county jail on April 15th, I thought.
That's correct. I was just giving the dates that they had on the system.
Okay.
All right, so does everybody agree that's 108 days?
Yes, Judge.
All right, and did he successfully complete ISF?
Yes, Judge.
All right, I'll give him credit for successful completion of ISF.
Thank you, Judge.
All right, then we will be off the record. Something else, Mr. Coons?
No, I was just going to ask if you could put me and my client in a breakout room and then excuse us from there.
Yes, I will. Mr. Gill,
Thank you so.
you have decisions to make in your life. Either you want to continue to commit crimes, go in and out the prison, in which case at some point in time, you're going to be the grandfather of the prison that people come in and ask how to get cigarettes. So it's completely up to you. The other thing you need to learn how not to do, and you shouldn't do, don't drag your brother down in nonsense that you're involved in. You understand?
Yes, ma'am.
Do you love your brother?
Yes, ma'am.
All right, so this was something very bad that you did to him. You understand?
Yes, Your Honor.
All right, I'm going to send you to breakout room number 1. I wish you the best of luck with your future endeavors. May they all be legal. I'm going to send you to breakout room number 1.
Thank you, Judge, and goodbye, everyone.
Goodbye. John, when you finish with him, just let us know. All right, Raymond Bell.
Yes, ma'am.
Yes.
Let me see if I can, there we go. I have to stand away so you can see my beaming figure. So- They said I can't talk close to you. I'm here on Christopher Garcia, Judge. I'm so sorry. We got confused. We did report this morning and we couldn't confirm what we were supposed to be doing. And I had to report to the 144 for a jury trial and a.
Okay, it's supposed to be back on July 22nd for jury trial.
Okay, so that's what I thought you were going to do, but I think it got the wires got crossed this morning. So
okay, no problem.
That's fine. I just like to release my client, and then I'll still talk to Joe Ray to see what we're going to do on this case.
All right. Do you need to speak with Joe Ray now or no?
If he's available, I'll be happy to. But I'm in the courtroom. I don't know if he's.
Oh, I'll send you to breakout room number 2. Thanks for coming in. I appreciate it.
I didn't know I was going to pick a jury right now, Judge. I was ready. I had my wet, muddy shoes, but I wore a shiny blue tie. It's like, I don't know. Judge says she's going to hunt me down for the jury. I was like, okay, let me just, I tell my staff's like, what are you going to do? I said, well, I'm just going to walk in. We'll take care of business. What else can I do?
Go.
Judge says if I don't walk in, you're going to send the bailiffs out for me. And I'm okay with it. Your bailiffs are nice folks. They treat me well.
Okay. And Norma, what's the date for Ramsey Gonzalez?
He's gonna follow this motion, Judge, and we're gonna hear it on Monday.
Okay, so we'll come back on Monday. All right, Eric Hernandez.
Yes, Your Honor, I'm still waiting to get the waiver certificate of right of appeal and consent to plea by Zoom for Mr. Martinez. But on Mr. McGarrity's case, I believe he came back at 2 o'clock. Your Honor, on that one, I spoke to Mr. Garcia. He's not sure if it's his case or David Martin's case to try. There is a couple of plea bargains that have been relayed to us. Mr. McGarrity expressed to me this morning that he's had frustration with us trying to meet by Zoom or over the phone and is asked to come into my office. I have arranged for that to happen this Monday at 12:30. He's got a ride already lined up. If I could get this recalled for next Friday to report to the court if we're going to be indeed going to trial or if there's going to be a plea that will work, or even if it's earlier than Friday.
All right, Norma, can we recall this for Friday? Do we have anything available on the 16th?
That's fine, Judge. I can put it for that day.
All right, we'll see you on the 16th.
All right, Mr. McGarrity, I'll see you on Monday in my office. Is he free to go, Your Honor?
Yes, he's excused.
Very well. And I'm just waiting for that paperwork to get done with Mr. Martinez and we'll be ready to go.
All right, thank you. And who are the parties, Nathaniel Navy, who are you here for?
Judge, I'm here for Ruben Coronado and Tyrone Shepard. Ruben Coronado was just a case that was recalled from your Monday's docket, and Tyrone Shepard were here on that bond setting from a couple weeks ago.
All right, Ruben Coronado, you need to pull off your cap and you need to stop driving. All right, now on Ruben Coronado, that's going to be a jury trial, correct?
Yes, Your Honor.
All right, so Norma, what date are we coming? Have you conferred with the state on a jury trial date, Nathaniel?
We didn't confer on a date, just about the case itself.
All right, do you have all the discovery?
I do, Judge.
Okay, so who will be handling this case?
I spoke with
Me, Your Honor.
All right, so if you could go to number 1, Nathaniel, and Ms. Ferguson, if you could go to 1.
Okay.
And Meredith, if you could go to number 1 and you all can confer on a court date for jury trial. Oh, I'm so sorry, Nathaniel. I thought I sent you to 1 already. There you are.
Marcus, I sent you a chat.
All right, Nathaniel Navy, you're back?
I am back, Judge.
Yes, Ruben Coronado.
We got a trial date from Norma,
Okay, what date will that be?
November 1st.
Nora, why do you keep putting people so close to my birthday? You know, I celebrate the entire month. All right, Brenna went to take a short break. When she comes back, we'll put that on the record.
Okay.
And then you have Shepherd, is that correct?
It's like.
Yeah,
Yes.
Judge, if I'm gonna have to re-sign out, my computer's doing that thing again where I'm stuck
Sure.
trying to get out, and then I'll come back in.
All righty.
And Judge, can I see you in a breakout room?
Yes. If you want, we can go back to number, we can go to number 3. All right, everyone, just give me a moment. All right, Eric Hernandez, what paperwork are we waiting for you?
The consent to plea by video conference and the waiver of right of appeal.
Okay, have you received it?
I have not. I don't know who generates that, if it comes from the court or the DA's office.
No, it comes from Ms. Ferguson, but I think she's sent it. There's been some crazy things that have been happening.
I sent it.
Okay. There, I'll send my email address in the chat just in case there's a misspelling, because sometimes that happens.
Okay.
Curse my cousin for having Gonzalez with an S in his name.
All right. And so then Nathaniel Navy, are you back?
I'm back, Judge.
All right, let's go on Mr. Coronado then. Court is calling 2019 CR 12123, State of Texas versus Ruben Coronado. Could I have parties announced for the record for the state?
Meredith McIntyre for the state.
For the defense?
Nathaniel Navy, Your Honor.
All right, and Mr. Coronado, I need you to unmute.
Got it, Your Honor.
Are you Ruben Coronado?
Yes, ma'am.
We're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Coronado, do you have any objections with us for appearing by video?
No, Your Honor.
All right, it's the court's understanding that an offer has been tendered to the defense. Is that correct?
That's correct, Judge.
And my understanding is that the defendant is rejecting the offer. Is that correct?
Correct, Judge.
Mr. Coronado, are you requesting a jury trial or do you want a bench trial?
Yes, Your Honor.
Do you want a jury trial or a bench trial?
Jury trial, ma'am.
Mr. Navy, have you received all of the discovery in this case?
Yes, Your Honor, I have.
All right, state, the court does not have a copy. Oh, no, I take that back. Discovery acknowledgement was tendered on August 25th, 2020. My understanding is that both parties conferred on a jury trial date and the agreed date was November 1st. State, any objections to November 1st as a jury trial date?
No, Your Honor.
Defense, any objection to November 1st as a jury trial date?
No, Your Honor, no objection.
Mr. Coronado, do you have any objections to November 1st as a jury trial date?
No, Your Honor.
All right, then, Mr. Coronado, your jury trial date will be November 1st, 2021 at 9 a.m. You'll need to appear in the 187th District Court. It's on the 4th floor at 300 De La Rosa. Do you understand?
Yes, Your Honor.
All right, what time do you need to appear in court?
9 a.m., Your Honor.
What day?
November 1st, Your Honor.
And which court?
187th.
All right, thank you, Mr. Coronado.
Have a good
We'll
one.
close
ma'am.
the record.
Thank you.
You're welcome. Right, and then the next persons you have is Tyrone Shepard, is that correct?
That's correct, Judge. He's in custody.
All right, what is happening with Mr. Shepard?
Judge, we're back here on a bond setting. I had filed a motion to reinstate his bond or in the alternative, request that you set a bond in the case. You reset the matter because the state or to allow the state to call a witness if they wanted to. And I believe they have the pretrial services officer here.
Okay, are there going to be any other witnesses besides the pretrial services officer?
No, Your Honor.
All right, and before we start with that, Nathaniel Navy, your client, Mr. Coronado, is zooming back in.
Oh.
Mr. Coronado, did you need anything? Coronado. You're muted.
Okay, I'm sorry. I just wanted to ask if I was excused.
Yes, you're excused. Thank
Okay.
you. All right, the court is calling 2021 CR 4086, State of Texas versus Tyrone Leonard Shepherd. Could I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
Nathaniel Navy, Your Honor.
All right, and are you Mr. Shepherd? If you could unmute for me, Mr. Shepherd.
Yes, ma'am. Yes, Your Honor, I am.
All right, we're proceeding by video. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor, no objection.
Mr. Shepherd, do you have any objections with us proceeding with this hearing by video?
No, ma'am. No, Your
All
Honor.
right, the defense filed a motion to set or reinstate bond or set reasonable bond. We were here previously on, I believe, June 28th. And then we were to come back today to continue with this motion to reinstate bond. Defense,
Your
did you
Honor-
have, yes?
Oh, sorry, Your Honor, the state also subsequently filed a motion to increase bond. Increase and amend conditions. It was e-filed. I don't know if, I know Mr. Navy did you see that?
I did. See that. I received it.
All right, just one moment. All right, the court is also in receipt of a motion to increase and amend bond conditions filed by the state. Defense, are you ready to proceed on that bond as well?
I am, Judge.
All right. Then since the state has filed a motion to increase and amend bond conditions, we have begun with your motion to reinstate bond. Did you have any more witnesses as it relates to your motion to set or reinstate bond, Mr. Navy?
No, Judge, I don't think that would be necessary.
All right, and then state you filed a motion to increase and amend bond conditions, but there is no bond set, is that correct?
Correct, Judge. And it was kind of also in response to what defense was asking, which was for if bond was reinstated for an actual lower amount than the original bond. And so ours would be to reinstate. We're not asking for remand without bond. We're asking for an increase
Okay.
on the original amount.
All right, state, do you have any witnesses?
We do, Your Honor. State calls Lauren Garza, who should be on the screen as the pretrial officer for Mr. Shepherd.
All right, Miss Garza, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Could you state your name for the record, please?
My name is Lauren Garza.
All right, state.
Thank you, Your Honor. Good afternoon, Lauren. Could you please briefly introduce yourself to the court and tell us what your current job is?
Yes, my name is Lauren Garza, and currently I am a pretrial services officer bond 3, and I specialize with the GPS unit as well as mental health.
And what kind of training did you receive to become a pretrial services officer with this particular unit?
The training that we received ultimately to become a GPS officer is we are trained to conduct interviews as well as interview defendants to get them released from jail who have GPS conditions, and as well as the training for our database that we use for the GPS monitoring, which we use Focal Point. And that training consists of knowing
Let me stop you there
how-
for a second.
Oh.
Let me stop you there for a second. I'm sorry. Before we get into Focal Point, I want to ask you, do you supervise as a pretrial officer a defendant by the name of Tyrone Shepherd?
Yes, I did.
And how long had you been supervising him as his bond pretrial officer?
It had been, let me see, I can get you a specific date. It had been a couple of months though, I'd say about 1 or 2 months since he had been previously released, or when his conditions got added from the special needs unit. But I can give you.
And And that's okay. Can you tell us, I want to draw your attention to what you were talking about earlier, focal point. Can you explain what kind of training you get to be able to use that system and what that system entails? Did you hear my question?
No, I did. You broke out.
Oh, I'm sorry. I said, can you tell us what kind of training you receive to use the system focal point and what all you use that system for?
Yes. So to use focal point, we were trained by the technicians that are employed through Bexar County. They're contracted from the Sentinel Monitoring Service. They're the ones that created focal point. And the training that we utilized from them is how to enter home zones for the defendants, exclusion zones for those individuals that have no contact orders, scheduling whenever they're allowed to go to certain places. And in addition to if they need to move their residence or anything like that. Also, we did learn how to put GPS monitors on the defendants as well as take them off.
Okay, and do you have your own work assigned computer that you access this focal point database with?
Yes, I do.
And is it password protected?
Yes, it is.
Do you have your own password to focal point?
Yes, I do.
Does anyone else have access to this?
No.
What kind of information does focal point provide on a specific defendant who's being monitored under GPS?
The type of information that is provided is, of course, the location of where they're living, as well as the places that they go to, a certain time range of where they're at, in a certain location. If they go to HEB, it'll tell us exactly from what time to what time they were there. It actually shows us the speed of how fast they're driving. And then, in other words, it also shows the exclusion zones for, like I said, the individuals that have a no contact order. It'll show their charging percentage. It'll show.
How does the database record this information?
Everything is just based off the monitor. Everybody is assigned a specific serial number to their specific profile. And so whenever somebody leaves an authorized zone, it automatically sends us an alert and automatically gets tagged on their file. Or if they go into low battery, if they generate a strap temp or anything like that, everybody has their own profile.
And is all that information captured in focal point?
Yes, everything's captured to the minute.
And how would you know if your computer wasn't functioning properly or this particular database wasn't functioning properly?
We get notified by either the website itself will send us a message that, an alert occurred, or if it's the whole system that's kind of crashing, then we get a phone call from the Sentinel Monitoring Service, which they're based out of California. And they'll let us know that they're having issues with the website, and we just have to wait for them to do like a nationwide reset.
Okay. So Lauren, I'm going to show you what's been marked as State's Exhibit number 1. And for purposes of the record, since we're doing this on Zoom, this has been emailed to the court reporter, the defense attorney, as well as the judge. So bear with me here. And Lauren, I believe you also have a copy yourself. I'm going to attempt to screen share here.
All right. Are you offering that into evidence?
I am going to be, Your Honor. Yes. Okay, Lauren, can you see what I have pulled up on my?
Yes, I can.
Is that the same image that I emailed to you as well?
Yes, it is.
Can you explain to the court what this is?
Yes, so that is an aerial view of Mr. Shepard's home zone. The whole green circle is what he had access to. Typically, when they live in an apartment complex, we do allow them the whole complex so that they can be able to take care of their laundry, go check the mail, stuff like that. So
But
that
this
is just,
zone, and just so we're clear, this zone includes, does it include more than just his apartment building?
right, it does. As
Does
you
it
can see,
Does it include more than just his apartment complex?
yes, it does.
And what was the date on this particular report?
It was June 7th.
And how did you generate this report?
So along with our training, we are able to run proximity reports. So part of that is as well as running reports where we can factor out a certain day and a certain time frame. So that's how I was able to generate this report is I factored in a certain date. As you can see next to the date, I started from 12 a.m. and ended it at 11:15 p.m. So all the points that you see on the screen occurred during that time frame.
And what is the name of the defendant that we're talking about here that's on this particular exhibit?
The name is, yeah, the name of the defendant is Tyrone Shepard.
And what is this an aerial view of? What location within Bexar County?
So this is his home address, which is the 1818 Rogers Road. So that is just the aerial view of the back part of the apartment complex because I think there's a little bit more to the front.
And this information that we see here, is this something that you can generate yourself? Like, do you type in these points?
Yes. So if I were to generate, or if I were to want to go back to the specific date or a specific time, then yes, I would input the date and the times into the side box, and then it would pull up these same exact points.
Okay, let me ask that again. I might have been a little bit confusing. I'm talking about the red pinpoints.
Okay.
That information there, is that something that you input, or is that
no.
automatically generated?
No, those are automatically generated because those are all the points that Mr. Shepard was at, all the places of the apartment complex.
On this particular date and time range?
Exactly.
And when you pull this information from the database, was there any reason that you felt like it wasn't working properly?
No.
Was your computer secure at that time?
Yes, it was.
And was the database secure at that time under your password protected access to this database?
Yes, it was.
And is this printed information in States Exhibit 1? Is it an accurate copy of the information that you generated from your computer?
Yes, it is.
And so, Your Honor, at this time, the state would like to admit States Exhibit 1 into evidence. Defense counsel.
No objection.
The copy.
All right, any objection? I'm sorry, Meredith.
Sorry. I said defense counsel has received a copy as well as the court and the court reporter.
Any objections?
No, Your Honor.
All right, then State's Exhibit number 1 is admitted into evidence.
Okay, and Lauren, I'm going to ask you a few more questions based off this with my screen share still on because I think it makes it easier to understand.
Okay.
Can you explain the red pinpoints 8 and 10 and what that little exclamation mark means?
Yes, so that exclamation mark means that they have entered past their home zone. So basically it's an unauthorized inclusion zone. So that's what those that's what that exclamation mark means, is that he is past his home zone where he's not supposed to be.
And so did Tyrone Shepard on June 7th of 2021, during that time frame here listed on exhibit number 1, did he ask for permission to leave his specified zone?
No, he did not.
And one more question on all these different points with different numbers. Number 5 there, is that his actual apartment building?
I'm sorry, what number?
Number 5?
Yes, number 5 is his apartment building.
Is number 3 up there at the top, even in his apartment complex?
Yes, that is on the other side of the apartment complex.
But it's a fairly wide range, correct?
Right. He's far away from his building.
Okay. And all the other points are still within that green zone?
Right, yes.
And do you guys ever have situations where you limit the zone to a smaller area within the apartment?
Yes.
Can that be done?
Yes, we have had some past instances where we have had to limit the movement around the apartment complex to where we just limit them to their own building, to their apartment building that they live in.
And is the technology capable of doing that under GPS monitoring?
Yes, it is.
I'm going to stop screen share for a second here, if I can. Okay, Lauren, the next thing I'm going to draw your attention to, so I lied, I'm going to screen share again, is exhibit number 2, which has also been emailed to defense, court, and yourself. Let me get the screen share. And Lauren, can you see this?
Yes, I can.
It's got multiple pages here.
I think if you hit the second button on the very bottom to your right, that middle button to the right, bottom right.
Oh, there we go.
Yeah, the middle one, the one right next to it.
Thank you.
Right there. Yeah, it
I
should bring
appreciate
up.
that.
Yeah, you're welcome.
So what is this a copy of?
So this is a copy of the update letter that I submitted them, let's see, on the 16th, referencing that there was a GPS device tamper with Mr. Shepard's device, and that the update letter was sent because a warrant was issued.
And are you the custodian of these records when there is a tamper or another issue with someone's GPS?
Yes.
Do you keep these records in the regular course of your business?
Yes, I do.
And when there was the issue on June 15th of 2021, how soon after that did you generate this report?
It was the day after.
So fairly close to the time of the incident.
Right, yes.
And is that your signature at the bottom?
Yes, it is.
And is this a true and accurate copy of the letter that you sent to the court with the device tamper issue?
Yes, it is.
Your Honor, at this point, the state would move to ask the court to admit State's Exhibit 2 into evidence.
Defense, any objections?
No, Your Honor, I believe you already have that.
Yes. State's Exhibit number 2 is admitted.
I'm going to stop sharing for a second. Okay, Lauren, I want to draw your attention to the tampering issue on June 15th. Can you explain how you got that information?
Yeah, so the warrant was issued that evening on the 15th. An email was sent out to us stating that a warrant had been issued. So the next morning I had to conduct the update letter because he refused to get his GPS monitor switched out, in which that's why the warrant was issued.
And also, did you receive a tamper alert from the monitoring call center?
Yes, we did at 5:28 p.m. on the 15th.
And once those two things happened, did you actually have a conversation with Tyrone Shepard about this incident?
Yes, so I didn't have the conversation with him until the 16th, the same day that I did submit the update letter.
And can you explain to the court what he told you about his monitoring device?
I would object to hearsay on that, Judge.
Your Honor, mission
Right,
by
and
party opponent.
You're asking what the defendant said?
Correct.
All right, that'll be overruled.
Go ahead, Ms. Garza. What did he tell you?
Yeah, so when I spoke to Mr. Shepherd the day on the 16th, I asked him what had happened with his device. And he stated that he wasn't sure, but he was able to put the monitor back on. So he didn't think he was in trouble or anything. And then that same day, we did have our GPS technician and an officer driving around to pick up GPS monitors that had been previously cut or tampered with. And I asked him if that would be okay, if we could send a technician to his residence, and he said yes. I then asked him if he could put the monitor in a HEB bag along with the charger and place it outside his residence so that way we didn't have to go inside. And he said yes, he could do that.
All right, just 1 second, please. Eric Hernandez, I need you to go to breakout room number 1. We don't have your client's paperwork. All right, I'm sorry about that. You can continue.
No worries. So did he admit to you that he took his device off?
Yes.
And was there a period of time that he was not being monitored at all per his bond conditions?
Yes, from the time that we received the tamper to when he got picked up, it was about 5 days that he wasn't being monitored by us.
Okay, Your Honor. The state will pass this witness. No more questions at this time.
All right, Mr. Navy.
Thank you, Judge. Good afternoon, Ms. Garza. You and I have spoken on the phone a few times, correct?
Yes.
Okay. Good afternoon. And you had a chance to review State's Exhibit 1 prior to today's hearing, I assume?
Yes, I did.
And on that exhibit, those red bullet points, number 8 and 10, where it showed that Tyrone was outside the allowable area of his GPS, those are barely outside that green circle, correct?
Correct.
Okay. So it's fair to say that if he did go out of that allowable zone, he was just right outside of it, correct?
Right.
And that area would still be somewhat close to his apartment complex. Is that fair to say?
Yes.
And there's no other violation for him, actually. There's no other violation that you received where he was outside of that zone at some other location far away from his complex. Would that be accurate?
So he has left his residence before. I never submitted a formal violation on him. He was just admonished for him leaving without my permission. But those are all in the chronos of his file on CSS.
Okay. And was he in contact with you about those instances?
Not until I called him one time, and the other time was when he had already went home. And when I called him, I had to explain to him that he had to ask for my permission to leave his residence. And at that point, he was frustrated because he didn't want to ask my permission. But then he realized that the only way he would be able to leave without getting in trouble was to ask for my permission.
Okay. And on those locations, number 8 and number 10, does it appear that there's some sort of creek on that map, or possibly maybe a walkway or a pathway? There's some sort of squiggly looking something like that. Is that fair to say that it's possible that that's what that could be?
Yeah, I wouldn't be able to confirm that. I'd have to go back and look like on the road view of it, just because those are the ones that show like the rivers and the pathways and all that. But yeah, I mean, those points are out of his apartment zone. So when I explained to him about him going to do laundry and check the mail and stuff like that, I told him that he needed to stay within his apartment complex property. And those points are outside of the complex.
Okay, well, it's fair to say that even though, and I don't know the boundaries of the complex, but that's not another location where there's another residential building or another commercial building or anything like that, correct? It looks like it's more or less some sort of undeveloped natural area, potentially a trail or something like that.
Right.
Okay. And has Tyrone ever expressed to you that sometimes he takes walks to help his mental state? Has that ever come up in conversation?
Yes, he did tell me once. He did ask if he would be able to walk. And I did tell him that it had to be within his complex, around his side of the buildings. So I did tell him, I did give him permission to do that, because I know he was going through, I think during that time, he did have a mental breakdown when he was on the phone with me. So I did allow him to go that day, but I did make it clear that he had to stay within his apartment premises and he could not leave.
Okay. And then would it also be accurate to say that you have no indication that he's ever left that allowable area in order to get in contact with the complaining witness in the underlying case itself? There's no indication of that.
That he left his residence?
No,
I'm sorry, you broke up.
Oh, I'm sorry. Can you hear?
Yeah, I don't know if it's my Wi-Fi or.
Okay.
Could you just repeat that?
Yeah, no problem. I was saying there's no indication from your end that he's ever left that GPS allowable area in order to get into contact with the complaining witness in the underlying case. Would that?
Judge, I'm gonna object that calls for speculation and it's outside her personal knowledge.
Well, I'm just asking if there's any indication that that's happened. I'm not asking her to say for sure one way or the other, but just that she has no.
That'll be overruled. You can answer the question.
Okay, yeah, I wouldn't know. I mean, the only time he's left was to go to the corner store. But no, I mean, he's never left his residence to go straight to where the complaining witness lives or anything like that. Because we do have that documented.
And when you say the corner store, was that one of the times where he left the allowable zone and just went to a corner store?
Yes, that time where I mentioned that he did leave without my permission.
Okay, and is that corner store, is that somewhat close to his apartment complex if you had to, if you had to estimate?
Yes, it's about, I'd say maybe 2 or 3 blocks. It is outside of his zone, but I know he used to walk there. So it's within walking distance.
Okay. And then when you were first supervising Tyrone, he was not subject to the GPS monitor. Is that correct?
Right. He wasn't a fan of it.
Okay. But once it was ordered, he did go and get the monitor. Isn't that correct? And get it installed?
Yes, he did go eventually get it installed.
Okay. And then another one of his conditions of bond was to have no possession of firearms, correct?
Correct, yes.
And an investigator from the district attorney's office went and picked up his firearms. Were you aware of that?
Yes, I was notified.
Okay. And Tyrone surrendered his firearms willingly and politely, to your knowledge. Is that correct?
Correct.
And there was no issues there?
No.
Okay. I have no further questions, Judge.
All right, any other questions from the state?
Just a couple, Your Honor. Ms. Garza, based on Exhibit 1 and his allowable zone, would he be able to go to his apartment pool where there are lots of different people there, potentially, and still be within his allowable zone?
Yes, he would be allowed to do that.
So he could be coming into contact with many people at this complex while under GPS monitor.
Correct.
And this operates a little bit differently than those people that are on house arrest that actually are in a house, right?
Correct.
And based on the issues we talked about before, would you say that he's been following all the rules and complying with his bond conditions?
In the beginning, he didn't, but towards the end, he did start complying. He did start calling me in advance every time he needed to go to the store. That's really the only place he asked to go because he needed water, groceries, stuff like that. And I did allow him, of course. But yes, towards the end of of supervision, he was starting to comply a little bit more.
Until the issues that we spoke about around this June 7th and June 15th, correct? The tampering?
Yes, correct. The tamper and the leaving of the zone on the 7th.
And that would be a violation of his bond conditions, correct?
Correct, yes.
No further questions, Judge.
Just briefly, Judge, are you, if I may,
Yes.
are you aware, Ms. Garza, where Mr. Shepard was arrested once the warrant went out for him?
I was made aware, I think Mr. Davis said that he was arrested at his residence, at Tyrone Shepard's residence.
Okay, so he was arrested at his apartment complex.
Correct.
Okay, no further questions, Judge.
All right. Any other questions, state of this witness?
No, Your Honor.
All right. Is she excused or subject to recall?
She's excused, Judge.
All right, Ms. Garza, thank you for coming in.
Thank you, Your Honor.
Any other witnesses from the state?
No, Your Honor.
Defense, any witnesses?
No, Your Honor, no witnesses, just argument.
Your Honor, if I can just for 1 minute, I need to plug in my computer. Can we just pause for 1 second?
Sure.
I'm sorry.
No problem. Oh, that's okay. It's a Monday on a Friday, but we're all still have smiles. Brenda, I'm telling you, these tiny laptops, they don't hold a charge that long.
I appreciate that, Judge. I've had to move spots quite a bit when we share an office on Zoom.
All right, so I know that everybody wants to do their argument, but if we could focus on the fact that he is on GPS, and from what I'm hearing and my understanding, and correct me if I'm wrong, but I think I heard the witness say that GPS was removed. Is that correct?
Correct.
So if anybody wants to address that issue in their closing argument, because the court's orders from, I think this is May 17th, if I'm reading my writing correctly, was he was placed on partial house arrest. He was allowed to attend all medical and mental health appointments and obtain necessities such as medications, groceries upon 24-hour notice. So if someone wants to focus their argument towards his removal of the GPS when the court placed him on GPS, that would be greatly appreciated. And
Yes,
so state, you may proceed.
Yes, Your Honor. I just have a few arguments as it comes to his bond conditions.
Yes.
Because the state did file a motion to when Your Honor does set the bond to increase it beyond what it was originally, which was $60,000. We are also asking for you to amend the conditions and make it such that, and the officer testified to this, that his allowable zone is more limited to just like his building, his apartment complex.
All right, everyone, just 1 moment. Can I see the state and the defense in a breakout room, please? If you all can go to breakout room number 2.
Yes, Judge.
We are back on the record. And the court will hear argument. State.
Yes, Your Honor. The state is asking for this court to amend his bond conditions. He had been allowed to be on partial. We are asking for him to be now on full house arrest. Should he make bond? Should this court post a new bond, no matter what the amount is, we ask for full house arrest, and we would ask that the allowable zone be not as wide as it has been based on his previous issues. We also ask that this court, when you do choose to set a bond, that it be doubled, that it be higher than the original bond, which was $60,000, based on the issues that we've been having with this defendant. We think he's a potential flight risk. He was not monitored for multiple days. He removed his own GPS device. He's been outside the zone. And the nature of the offense, Judge, the safety of the community. His allowable zone is large enough that he is able to interact with many different people within his apartment complex. And we just feel like it's a safety issue for the community. And we are asking this court to set a higher bond than the original bond. And should he bond out, it be on full house arrest instead of partial.
All right, defense. Oh, Nathaniel, you're muted.
There we go. Okay. I said, thank you, Judge. I would just argue when my client bonded out initially, he did not have this as a condition of bond. And there was no violation that caused the state to file a motion to amend his bond for the GPS. They merely did it because of the alleged facts in the underlying case itself. My client was actually agreeable to the GPS in the first place. He didn't have any issue with it. He agreed to it. It wasn't something that he tried to fight or anything like that. It was just due to what the state believed was the nature of the underlying allegations, which, you know, as of now, he's innocent until he's proven guilty, Judge. And I think what this hearing showed too, Judge, was that I hear that the state says that they're concerned about a flight risk. I don't think he's a flight risk. When he's outside of that allowable zone, it's right there in the back by his apartment complex. He's when he was arrested days later, they say he wasn't supervised for 5 days. Well, it wasn't like he went anywhere. He was arrested in his apartment complex, and speaking with him, he was just making chicken at his apartment when he was arrested and asked the investigators to turn his oven off so that it wouldn't remain on when he went into custody. And in speaking with him, we agreed that it would probably be in his best interest for this hearing to come clean and admit that, I know that there's been evidence presented too. He did remove the GPS. He stated that it was just getting extremely uncomfortable, cutting off his circulation when he would exercise. It was just something that he was having physical issues with. He said it would just go off at random times, and he did not know why. I don't know if it was because it was losing charge and that's just what it did, but so there was some issues with that. He knows that he should not have done that, Judge, but I think when we look at what are the purposes for GPS, number one, so that he's not a flight risk and doesn't leave and go somewhere. The place that he did go that the officer stated without asking was just to a convenience store down the road. And the other two locations look like it's just some either creek or potentially like a trail or something like that outside of his apartment. So he's not even going anywhere. He's just staying near his apartment complex. His family, who's on the Zoom today, they're from Georgia. He is having some issues with his apartment complex, potentially evicting him. So they were going to come in and help him get his things and find a new place. He does have support. His mother requested if it would be possible, and I don't know if the court would consider it, but allowing Tyrone to move in with her while this case is pending. She stated that she would keep an eye on him, get him any sort of help or treatment that he needs, and keep him in line. She's willing to do that, Judge. My client understands he's willing to get the GPS back on, even if he's restricted just to his apartment complex. That wouldn't be an issue. And due to all those reasons, Judge, I would ask that you reinstate his bond and give him another chance on his GPS. If you're unwilling to do that, to allow him to post a $15,000 bond, Judge, just because financially the $60,000 bond, which he did post originally, is quite high. This would be in addition to that. And when we look at the main purpose for a bond, it's to ensure that he appears to court. He's never had an issue not appearing to court or anything like that. And like the issues that I went over before, I don't think he's a flight risk. I fear that, potentially the reason for raising his bond so high makes it an instrument of oppression rather than what the purpose of a bond is to be for, which is to assure that somebody shows up to court and faces the charges that he's accused of. And of course, he's willing to do that. There's been no issues with him being on any sort of court calls. And even if he did bond out, he would appear to court as requested and whatever his court dates are. So I would just remind the court, that would just be my fear is what is the purpose of raising it to that amount, if not to use it as an instrument of oppression, just to be sure he doesn't get out, when the main purpose of the bond is just to ensure that he does appear to court, Judge. And for all those reasons, I would request that you reinstate his bond with the GPS full house arrest. He's willing to do that. But if the court is unwilling to do that, and the alternative, to set a bond in the amount of $15,000.
All right, State, it's your motion,
Yes,
so I'll
Your
give
Honor.
you final argument.
Okay. A few things on this matter, Your Honor. The state, as the court and defense is aware, is not even asking this court to remand him without bond. That's not even what we're asking, and we could in this instance, but we chose not to. So it's not an instrument of oppression. Anytime someone has issues with their bond conditions on a serious offense, like the one we're here for, a serious violent offense, we don't reward them by then cutting their bond down to $15,000 or saying, sure, you can go to Georgia. No, it's for the safety of the community, given the seriousness of the offense and the fact he's had continued issues with his bond conditions, that we are asking for this court to double his original bond.
All right, this is what the court is going to do. I went to the breakout room with the state and the defense. We're going to come back on Wednesday. On Wednesday, I'm going to make my ruling on the bond amount. I'm going to make my ruling as it relates to the GPS. Defense is going to look into potential places or residences for Mr. Shepherd to stay. Because if he makes bond, Mr. Shepherd, you will not be allowed to leave the state of Texas and go to Georgia. I'm not going to allow that. So we're going to come back on Wednesday. That way, both parties will have a chance to look into potential residences for Mr. Shepherd. And that will give us a chance to see what the update is on the psychological evaluation. Defense, if you don't mind me asking your client, Mr. Shepherd, could you unmute yourself? It's the longest space, is the space bar. Just hold down the longest bar on the keyboard. Just keep holding it, yes. Just hold it down.
Okay.
All right, Mr. Shepherd, has someone visited you to give you an evaluation yet?
They visited me yesterday. I was speaking to someone, I was speaking to military personnel outside of here, and I just feel more comfortable because in here, I feel...
No, Mr. Shepherd, I'm not getting into the facts of your case. I'm trying to figure out whether or not someone has seen you to talk to you about any mental health issues. So has the doctor come to visit you at the jail to speak with you? Because that was ordered by the court.
They came to speak with me, but I did not speak with them about any mental health stuff.
Okay. So Nathaniel, perhaps if you want to talk to Mr. Shepherd about that. Okay. And we will come back on, Norma, are we able to come back on this on Wednesday, or do we need to do it later in the week?
We can do it on Wednesday, Judge. I can put it for Wednesday.
All right, Mr. Navy and State, will that give you a chance to look into whatever you need to look into?
Yes, Judge, you will.
Yes, Judge.
All right. So we're going to come back on July 14th. And Norma, just set it for the afternoon at 2 p.m.
Yes, ma'am.
All right, and then Mr. Navy, I'm going to send you to a breakout room with your client to speak to him about that evaluation.
Okay, thank you, Judge.
You're welcome. I'll send you to breakout room number 1. And Mr. Shepherd, if you can go to 1.
Yes, ma'am.
Did you want his family to remain to speak with you, Mr. Navy?
I can call them on the phone, Judge. So if they want to be excused, we can talk on the phone after this.
All right, to the family of Mr. Shepherd, yes. His attorney said he will call you this afternoon. All right. So are we ready? Oh, I'm sorry, you're not allowed to speak to your son.
Thank you.
All right, you're welcome. All right, Eric Hernandez, are you ready? This is our last case for today.
I am. I think I just heard Etta James singing at last. Oh, we're ready,
Yes,
Your
we
Honor.
have the paperwork.
Yeah, I checked my actual Gmail account. That's where Ms. Ferguson sent it to originally, and I hadn't checked that one. So that
Okay.
was on me.
All right, no problem. Let me set us up here. Court is calling 2021 CR 3507, State of Texas versus 1 Antonio Martinez. Could I have parties announced for the record, please, for the state,
Joey Garcia.
for the defense?
Eric Hernandez for the defendant, Juan Martinez.
And are you Mr. Martinez?
Yes, ma'am.
Proceeding by video, any objections from the state?
No, Your Honor.
Any objections from the defense?
None, Your Honor.
Mr. Martinez, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Hernandez, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We'll waive, Your Honor.
State, are you proceeding on the indictment as presented?
State is waiving the habitual enhancement paragraph.
No
Any
objection.
objection?
None, Your Honor.
Mr. Martinez, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, I did. Yes, ma'am.
You understand what you're charged with is assault family second offense. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
You believe he has a rational as well as a factual understanding of the charges against him?
I do believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you a U.S. citizen?
Yes, I am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney, and did you understand it?
Yes, yes, ma'am.
According to the plea bargain agreement, the state is requesting 2 years in the prison, $1,000 fine, affirmative finding of family violence, no contact with Adelicia, Licia, Casares, Casarez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
It is our agreement, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge, it is.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
State offers State's Exhibit 1 and all its attachments.
Any objections?
None, Your Honor.
Mr. Martinez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We'll proceed, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we've talked about it extensively. He understands what he signed up for, and I believe we're just asking for the court to honor the 2-year TDC recommendation of the state.
The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $1,000 fine, time and money reward concurrent. There's an affirmative finding of family violence, no contact with Adelicia Casares.
Yes, ma'am.
Next, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction and because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we will close the record. Mr. Martinez, how old are you?
46, ma'am.
All right, here's the thing. You could have easily been looking at a minimum of 25 years in prison. Obviously, you have anger issues. You need to work on that. That's you need to work on you, not somebody else that needs to work on you. You understand?
Yes, I do, ma'am.
My advice to you, and I tell this to everybody, don't get in a relationship until you can keep an orchid alive and blooming for a year. An orchid requires you to be patient, to be gentle, because you can't move it around a lot. If you can't keep an orchid alive, you shouldn't be in a relationship. You understand?
Yes, ma'am.
And what's up with the tattoo on your chest?
You're on mute, Mr. Martinez.
It just says Mexican.
Okay, well, we all know what that means. So here's the thing. I imagine you just want to continue to get more tattoos. You can do that. But I will tell you this. Gang affiliations, you shouldn't be doing that. You understand?
Yes, ma'am.
All right, good luck to you.
Thank
Don't
you.
end up being the grandfather at the prison, okay?
Yes, ma'am.
All right, Norma, you can let them know that 14F can go back.
Yes, ma'am.
All right, thank you, Mr. Hernandez.
Thank you, Judge. Have a good afternoon. Or
Oh,
have a good
thank
weekend
you.
at this point.
Oh, we're gonna have a great weekend. All right, I'm gonna stop live stream. It's been a Friday on a Friday. We kept it as a Friday because we all kept our patience. See everybody on Monday, and we're gonna start Monday at 9:45.